Edwin Vieira, J.D., Ph.D., constitutional law professor from Harvard concurs. The fact is, Obama is not eligible to be President of the United States because he could never be a natural-born citizen as required by Article 2, Section 1, Clause 5 of the United States Constitution. Those perpetrating fraud have abused the 14th Amendment's intent to make former slaves into full-status citizens, not to allow foreigners to usurp the office of the presidency. They are abusing the goodwill to fully grant citizenship to those unfairly denied, to in essence make all Americans into slaves of an ineligible illegal foreign usurpation of our precious Constitution. No statutory naturalized at birth or naturalized after birth citizen is eligible to be president. Only a natural-born citizen is eligible. A mere citizen can serve only in Congress or Senate. The term citizen has a generic meaning and a legal meaning. Citizen means belonging to a nation. But in the legal realm, citizen has specific definitions in the United States. There are two types of citizens. The first type is all naturalized citizens, also known as statutory citizens, and the second type is natural-born citizens. Confirmed by Blackstone. Naturalized citizens include naturalized after birth or by manner of oath, or naturalized at birth citizens. All naturalized citizens are made so under by positive law, statute, treaty, man-written rules, and acts, to wit the 14th Amendment and Congress's Article 1, Section 8, Clause 4, a power to make uniform the laws of naturalization. In no case does a natural-born citizen ever have any first-generation tie to any foreign nation by blood or soil. They are citizens by nature. This is consistent with Vattel's Loi des gens, upon which the Constitution is based. U.S. Code 1401 defines all naturalized at birth U.S. citizens. Section H is for persons born before 1934. Section G is for one alien parent plus one military parent baby born out of country. Section F is for unknown parentage child found in USA under age 5. Sections E and D are for one U.S. citizen parent with baby born out of country. Section C is for two U.S. citizen parents with baby born out of country. Section B is for one U.S. citizen parent and baby born in the USA. Barack Obama, if born in Hawaii, for which he lacks any documentation, but if so he would be a U.S. Code 1401 Section B naturalized at birth statutory U.S. citizen, since he had one U.S. citizen parent and one alien parent and he claims he was born in Hawaii. Thus not eligible to be president as merely a citizen and not a natural-born citizen. 1401 Section A is for those born in countries subject to jurisdiction, which is for babies born in the USA with no foreign citizenships. 1401 Section A is based on the 14th Amendment, which reads, quote, all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside, end quote. Barack Obama, if born in Hawaii, for which he lacks any documentation, but if so he would be a U.S. Code 1401 Section B naturalized at birth statutory U.S. citizen, since he had one U.S. citizen parent and one alien parent and he claims he was born in Hawaii. 1401 Section A is for those born in countries subject to jurisdiction, which is for babies born in the USA with no foreign citizenships. Based on the 14th Amendment, which reads, quote, all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside, end quote. The purpose of the 14th Amendment was to grant citizenship to slaves who were without a country, and thus their second-generation descendants could be natural-born citizens too. The 14th Amendment was not intended to alter the definition of a natural-born citizen. Indeed, the only omitted terminology and permutation is that for a natural-born citizen. Look carefully in the 14th Amendment and U.S. Code 1401. The term natural-born citizen and its definition are specifically omitted. The Civil Rights Act of 1866 and 14th Amendment precludes anchor babies from naturalized at birth U.S. citizenship, since they have foreign citizenship due to their parents' citizenships at birth. Their parents' countries can make a first-generation claim of citizenship. U.S. Code 1401 Section A was written for slaves born in America. It was not written for the babies of foreigners who enter the country illegally. The Supreme Court has never rejected any eligibility suits since it has already decided on the definition of natural-born citizen, and no modern suits have been adjudicated, and no previous holdings have been overturned. In 1874, in the holding of Minor versus Happersett, it was held no 14th Amendment U.S. citizen is ever a natural-born citizen. This is so because the 14th Amendment was added to the U.S. Constitution in 1868. And the holding states that the definition of natural-born citizen is not in the Constitution, thus not in the 14th Amendment. A 1401 Section B naturalized at birth U.S. citizen is not eligible to be president by the precedent holding in Minor v. Happersett. By having an alien father, he was never eligible to be president. Also, Minor defines a natural-born citizen as born of citizen parents plural in U.S. soil. A natural-born citizen is the status at the moment of birth. Nothing afterward affects it unless a person gives up their American citizenship altogether, per the holding in Perkins v. Elg. The first presidents were British subjects and had fathers who were foreigners too, and they were not natural-born citizens either, but were eligible because of the grandfather clause in Article 2, Section 1, Clause 5 of the U.S. Constitution. If a would-be president was alive at the time of the ratification in 1787, they only had to be a U.S. citizen to be president, not a natural-born citizen, because the nation was too new. But if they were born after 1787, they had to be a natural-born citizen to be president. The first presidents were all U.S. citizens because on July 4, 1776, all willing residents of the early United States became its citizens via the Declaration of Independence and their support of the American Revolution. Article 1 requirements for Congress are age 25 and 7 years a citizen, and for senators age 30 and 9 years a citizen. This was possible for the first U.S. government since the ratification took place 11 years after the signing of the Declaration of Independence. However, in Article 2, the requirement for presidents born after the ratification is that they are all age 35, a natural-born citizen, and 14 years a resident. The reason Article 2 says resident and not citizen is because by the legal definition, a natural-born citizen is not a statutory citizen. U.S. v. Wong Kim Ark holds that a citizen has no fewer rights than a natural-born citizen. But being president is not a right, it is a highly discriminatory position requiring the highest echelon of standards, which Barack Obama has an obligation to meet but has never and can never meet. Naturalized citizens include naturalized at birth and naturalized after birth citizens. Those persons born of two foreign parents, anywhere, to obtain U.S. citizenship need to naturalize after birth or meet certain standards and swear an oath. There were no laws implemented for naturalization by oath until well after the ratification, so the first Congress and Senate were citizens by the Declaration of Independence. In Article 2, the term citizen is clearly differentiated from natural-born citizen by use of the term or, and since citizens were made so by laws, it is clear that natural-born citizens were made so by nature. The following quotes are repeatedly scrubbed and removed by Obots from Wikipedia. They and the media have consistently lied to the public about the truth of Obama's lack of eligibility. John Bingham, while speaking on civil rights of citizens in the House on March 9, 1866, said, quote, "I find no fault with the introductory clause of Senate Bill 61, which is simply declaratory of what is written in the Constitution, that every human being born within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty is, in the language of your Constitution itself, a natural-born citizen," end quote. In the Supreme Court precedent case Minor v. Happersett, the definition of natural-born citizen is laid out, quote, "at common law, with the nomenclature of which the framers of the Constitution were familiar, it was never doubted that all children born in the country of parents who were its citizens, became themselves, upon their birth, citizens also. These were natives or natural-born citizens, as distinguished from aliens or foreigners," end quote. In the Supreme Court precedent case Perkins v. Elg in 1939, it actually gives examples of what a natural-born citizen, a citizen is, and what a native-born citizen of the U.S. is. In this case, the U.S. Supreme Court found that a natural-born citizen is a person who is born of two U.S. citizen parents and born in the mainland of U.S. in U.S. v. Wong Kim Ark Justice Gray holds that the native-born child of an alien is just as much a citizen as is the natural-born citizen child of citizens. He compares two children born in the U.S., one a child of an alien, like Obama, who is a citizen, and another child born in the U.S. of citizens, who is a natural-born citizen, and he states that both have the same rights as citizens. However, being president is not a right. Obama co-sponsored Senate Resolution 511, which defined a natural-born citizen as requiring two U.S. citizen parents, so even he agrees with the definition of natural-born citizen held by precedent. The evolution of Obama lies to cover up the fraud is appalling. At first they tried to say that all U.S. Code 1401, citizens at birth, were natural-born citizens. But when one examines this law, which defines all naturalized or statutory citizens at birth, the one omitted permutation is two U.S. citizen parents born on U.S. soil. So their lie didn't work, because then they would be saying that a two U.S. citizen parents born on U.S. soil child is not eligible, when, in fact, that is the only permutation which is eligible to be president. Later their lie evolved to naturalized only, meaning by oath. But since there were no oath naturalized citizens until well after the ratification, this fails too. In Ankini they utterly misquoted U.S. v. Wong Kim Ark. The Obots always try to misdirect away from the Constitution. Some say that old Supreme Court precedents do not matter. Some say the Constitution is too archaic and hard to understand. Some Obots try to say that Britain should not govern who can be our president, which is misdirection from Obama's failing of Article 2, but they do acknowledge Obama was born British, and thus not a natural-born citizen. It is his father being an alien, a foreign citizen, which makes Obama ineligible even if born in Hawaii. If he was not born in Hawaii, he is just an illegal alien, because in 1961, if his American mother gave birth overseas, then she was too young to transfer U.S. citizenship. But let's look at the Hawaii birth situation. Obama has no documentation from Hawaii. The chief elections clerk Tim Adams has testified under oath that there is no documentation. The governor of Hawaii, Neil Abercrombie, issued a search warrant and found no documentation. The Hawaii Attorney General will not corroborate any statement as to any documentation. The Hawaii Democratic Committee refused to attest to Obama's eligibility on their balloting form. The ostensible cold digitized image on Obama's websites is the third version portrayed, and this form is the result of an application for a late birth certificate in Hawaii. It is not a birth certificate. Until a late birth certificate application is vetted, approved by the official state registrar, the form will only say, filed by registrar, as does Obama's, which is not approved. Obama's image states that it was filed by registrar, which means that the Hawaii Department of Health received his late birth certificate application from 2008. The desk clerk registrar filed it, but the official state registrar never approved his late birth certificate application as being valid. In short, the ostensible code is utterly meaningless and is used as misdirection from the inescapable legal facts based on the Constitution. Barack Obama, or whatever his real name is, fails Article 2 as well as the 20th Amendment, which required vetting of his eligibility. The media has lied. We have to free the political prisoner Dr. Terry Lakin now. Lakin is a decorated Army doctor. Lakin asked to see Obama's birth certificate to verify he was eligible as his commander-in-chief. Lakin is now being tortured in Leavenworth because Obama has no documentation, and the corrupt courts punish the innocent officer who stood up for his oath to defend the Constitution. Remember, everything Obama has signed and done is illegal and will eventually be overturned, as he has no constitutional authority. He is a fraud and an impostor, a usurper, an espionage agent. We must fix this to save this nation. And yes, the GOP and Democrats, the Supreme Court, everyone knows very well that Obama is a fraud. They are guilty of misprision of felony. They are in violation of their oath of office. They cannot think the biggest case of fraud perpetrated on the United States in its entire history is just going to go away. It is documented in history forever. The truth has a life all its own.